Good morning, ladies and gentlemen. Welcome to the BCA-SISV Restart webinar, Public Sector Contract and Cost Management under COVID-19. I'm Hui Wen from BCA. We are very grateful to have the Singapore Institute of Surveyors and Valuers, SISV, in joining us today to organize this live webinar. With the enactment of the COVID-19 Temporary Measures Act 2020, it is important for us to help stakeholders be better informed and prepared to navigate through the uncertainties for the longer-term business sustainability. Hence, this webinar will share on how this contractual impact on public sector projects can be managed effectively from the perspective of the various stakeholders and legal practitioners. Before we start, please note that as participants, you're on mute setting. Should you have any questions about the discussion topics, you may do so by clicking the Q&A button on the screen to type in your queries. When we get to the Q&A session at the end of this webinar, we will also be activating the raise hand function to take live questions from the audience. Should you wish to ask a question verbally at that time, do click the raise hand icon. Do also note that when the session ends, you will be directed to access an evaluation form after you have exited the webinar. Once submitted, you will be able to download the speaker's presentation materials via the website as shown. Today, we are pleased to have Mr. Koh Zi Boon, President QS Division, SISV, and Architect Leong Kok Suming, Managing Director, BC Academy, to co-chair the session. Together with them, we have Mr. Satya, Partner, Allen & Glade-Hill LLP, Architect Chan Kok Wei, Managing Director, SD Architects and Associates, Mr. Kenneth Liu, Executive Director, Chief Operating Officer, Straits Construction Group, Mr. Colin Chow, Director, Civil and Legislative Policy, Ministry of Law, and Ms. Lim Pui Shan, Deputy Director, Human Policy Department, BCA. Without ado, let us invite our webinar co-chairs to deliver their welcome remarks. Mr. Koh and Suming, please.
Hi, good morning, everyone, and friends of the built environment industry. SISV is delighted to partner with BCA on this Restart webinar series, focusing on public sector contract and cost management under COVID-19. And on behalf of BCA and SISV, together with my co-chair, Suming from BCA, we would like to warmly welcome you. So this webinar will be focusing on the provision under COVID-19 Temporary Measures Act, in short, COMAC, from the perspective of public sector contract. And we are delighted to have a well-represented speakers and panelists. And we have representative from MinLaw, Mr. Colin Chow, who will be sharing on the overview of the Act and some focus on Section 5 and Section 6 of the Act. And of course, next speaker will be actually Satya, who will be bringing some practical relevance through case studies, and he will share the legal perspective as well. And I believe that also with the well-experienced panelists, we will have very good and practical insights discussion. And I believe that we will certainly benefit from both speaker and a good discussion. Looking forward to a good webinar. I shall now hand over to my co-chair, Suming, to share her welcome thoughts. Suming, over to you.
Hi, good morning, everyone, friends and colleagues from the built environment sector, and thanks very much, Zaboon. Really welcome to this contracts and cost management webinar. This is really actually our 19th webinar that we have been organizing or co-organizing with industry, mainly the trade associations and chambers, since the restart happened in early June. And over 25,000 participants have actually attended many of these webinars. We will continue to do so with these webinars, providing a touch point to discuss and to further clarify challenges or uncertainties that industry have with regards to various methods or various processes with on the restart process, as well as the industry now progress towards accelerating work on site, more projects picking up and all that, towards recovery and of course longer term resilience. This will be our continued commitment and partnership with industry to continue to engage you through these webinar platforms to have an opportunity for exchange. I would also like to say that since the 10th of August, permission has been given for built environment sector firms to proceed with their work, and restart applications are no longer required, only for projects that are happening on site that a restart application will be required. So with really the opening up and the freeing up of a lot more of our processes, we hope to see the industry getting back to normal or the new normal as soon as possible. So with that, I encourage everyone to share your thoughts in the Q&A section, as well as to participate in this webinar, giving your perspectives. Back to you, MC. Thank you. We've lost the MC?
Sorry, there's some connection in my area. Yeah. Thank you, Mr. Gu and Tzu-Ming. First up, we have Mr. Colin Chow, Director, Civil and Legislative Policy for Ministry of Law, who will be sharing an overview of relief measures under the COVID-19 Temporary Measures Act 2020. Mr. Chow, over to you, please.
Thank you, MC. Thank you, co-chairs. Good morning, everyone. Time is short this morning, and a lot to cover, so I'll just jump right in. I thought I'll start off by sharing a little bit about the government's thinking when we designed and put together the COVID-19 Temporary Measures Act. And then after that, with that context set out, I will explain a little bit about the features of the Act in relation to the construction industry. So I think we all know the COVID-19 situation now. It's hit Singapore quite bad. But if we cast our minds back to earlier in the year, or even in 2019, I think we all thought that was a problem that is only stuck in China and Wuhan. It hit our shores finally in January. On February 9th or February 7th, I can't recall the exact date, we declared laws gone orange. People panicked. You will remember people going to the supermarkets fighting to buy toilet paper. But I think even then, no one could imagine the lasting, immediate and significant impact which COVID-19 will have on the economy, on our daily lives. I mean, we wouldn't usually have had a webinar of 1,000 over participants in the BAU kind of situation, but here we are now. For the construction industry, I think it's important to also look back at what was happening in April. I think maybe for the construction industry, you have felt the effects a little before other sectors, because even in December, January, some of the supply chains were disrupted. Immigration was also disrupted. So supplies, manpower started to become a problem. And projects were, I think, starting to get delayed. So at that point in time, what did the government do? By March, we announced the resilience budget. In early April, DPM announced the solidarity budget. We put in, at that time, almost about $30–40 billion into the economy. And so government was pumping in substantial funds to help the economy, help businesses keep afloat, and most importantly, to save jobs. But what we were seeing also was that the market was finding it difficult to adjust and adapt and be flexible to deal with COVID-19. There were threats to sue, or people already suing, threatening to terminate contracts, etc., etc., in relation to breaches and delays in performance of contractual obligations. Now, actually, in the context of COVID-19, those delays and breaches are really nobody's fault. It's not like someone had a choice and willingly defaulted. The pandemic hit in a way which was precipitous and totally unexpected. So there was very little ability for contracting parties to have planned for this. You could say you should be prudent and do all sorts of things, but I think it's generally accepted that there are a lot of problems with dealing with COVID-19, so much so that contracts became impossible to perform. So what we saw at that time was, I think did not gel with what the government was doing. Even as government was pumping in lifeblood into the economy was bleeding because parties were suing each other, threatening to sue, and things were grinding to a halt. So what we had to do, in addition to the government budgets and circuit breaker, was to put in a legal circuit breaker. My minister likes to say that, as we pump in the blood, we also have to staunch the bleeding. So what we wanted to do was to put in a temporary moratorium for legal enforcement action. Ordinarily, the Singapore government upholds the rule of law, and we are very, very cautious in intervening in private arrangements. But this is not ordinary time, it's an extraordinary time. So we had to intervene. But even as we intervened, we decided that we'll do it in a very narrow, targeted manner. It's narrow and targeted in several ways. First, it only applies to several scheduled contracts. I think there are about 7 main categories of contracts which are prescribed now. The measures will only last for a limited period of time. The Act has a long stop date of 1 year from the date of implementation. But the first tranche of the prescribed period is only for 6 months. It's coming up on the 19th of October. It's also limited in the sense that the relief given is limited. Generally, the relief is a moratorium against legal and enforcement action. For construction industry and events contracts being things like wedding contracts and things like that, we intervene a little bit more. For construction contracts, we also created a statutory defense for breach and delays, which are materially caused by COVID-19. So with that context, I'll just go into explaining how the relief works. This shows you basically the process. First, the contracting party has to see if the contract is covered by the Act. If it's not covered by the Act, then relief obviously not available. The party seeking relief must serve a notification for relief on the other party to the contract. The other party, once it receives the notification for relief, then the relief will apply. So you must receive it, it must have been served effectively on you for the relief to apply. And then lastly, if there are any hardships, and then if there are any disagreements about the reliefs or about the NFR and so on, those disputes are to be determined by assessors, which is a much faster, quicker way to deal with such disagreements. And it's free. So the first thing I want to explain is about the scope and eligibility for relief. So first of all, you have to be a contract covered by the Act. In relation to your industry, it's important to note that we have defined the contracts to be construction or supply contract within the meaning of the Building and Construction Industry Security of Payment Act. It is slightly broader than some of you are familiar with. It would also include things like renovation contracts. It only applies to contracts entered into before 25th of March 2020. The reason is that if you entered a contract from 25th March 2020 onwards, we expect that you would already be aware of COVID and its consequences, so you enter into these contracts eyes wide open. It also only applies to contractual obligations to be performed on or after 1st February 2020. That's when we assessed the impact of COVID-19 to have hit Singapore. So before that, if you can't, perform a contract, it's likely not due to COVID-19. And lastly, you must show that the contractual obligation could not be performed due to COVID-19 and not some other failure or reason on the part of the contracting party. The notification for relief is in a standard form. It's on the MinLaw website. You can go to our website to look for it. It's quite easy to use. For companies, you have to use your corp pass, you log in, fill up the details of yourself and of the other contracting party, and the electronic system can actually help to serve the notification for relief on the other side. If for whatever reason you don't have email or some electronic system, then you can also download the form manually and serve it manually. Coming to the meat of it, the reliefs. The first main relief, which applies to all the contracts in the Act, is a temporary moratorium against certain legal actions. Okay, so the party receiving the NFR cannot commence or continue an action in court against the defaulting party. You also cannot make an application for the winding up of defaulting parties. But note that we carved out SOPA adjudication proceedings, so parties can still commence or continue adjudication proceedings under SOPA. Additionally, because we don't want parties to enforce the contract which has been affected by COVID, we thought it was important also to prevent the calling on a performance bond. So calling a performance bond or equivalent earlier than 7 days before date of expiry is not allowed. But of course, we were aware that sometimes there is an expiry date. So if we prevent you from calling on a performance bond, then there could be some problems. So the defaulting party can apply to extend the term of the performance bond to 26 October, which is 7 days after the end of the prescribed period, or such other date as may be agreed among the parties. Defense against delay damages. So this is what I was talking about earlier. Many contractors couldn't perform the contracts in accordance with the schedule, not through their fault or not by their choice, but because of the circumstances imposed by COVID-19. So for the purposes of determining the period of delayed performance, when calculating liquidated damages or delay damages in general, the period where the subject inability is caused by COVID-19 and it's between 1st February to 19th October 2020 will be disregarded. Similarly, there's a defense to a claim for breach of contract. So again, if your breach is due materially to COVID-19, then and it falls between 1st February to 19th October 2020, then you can raise this as a defense when there is any legal proceedings in relation to this subject inability. But I must emphasize that you can only raise these defenses if you have first served your notification for it. Now, the assessor framework was designed because we anticipated that, whilst we put this across the board, this relief mechanism, there could be some hard cases around the fringes. So we now have a volunteer core of about 300 assessors coming from the legal and accounting professions who will come and help to look into any disagreements that parties might have in relation to the notification for relief. So they can apply for assessment and they will look into whether the notification for relief is valid or not. But for construction contracts, it's very limited. They will not go and look into what is the period of delay, how much damages are due, what is the whether you are allowed extension of time. They will also not help you renegotiate your contracts. They'll simply say whether this is a contract to which, or this is a situation to which the Act applies, whether the temporary relief applies, and that allows parties to have a slight reprieve until October 19th. And then after that, when you do your adjudication, arbitration, and litigation, you rely on the defenses and other things like that to try and resolve the matter. But I think the government hopes that parties can be reasonable to one another, use this time, try and negotiate, because it really does nobody any good if everyone is just stuck and embroiled in litigation, arbitration, or disputes, rather than focusing the energies on reviving the sector and reviving the economy. Okay, so that leads me to thank you for listening to me, but I also take the opportunity to just again emphasize this is a situation which has hit everyone hard. The government has put in significant measures to try and help, but everyone has a part to play to try and work together so that all of us can come out of this stronger. I'll leave it to Satya to take over now.
Thank you, Mr. Chow. Next, we have Mr. Satya, partner Allen and Glithill LLP, who will be sharing on the impact of COVID-19 Temporary Measures Act 2020 and how industry could better navigate the current situation with good practices in contract management. Also, the recent amendments in PSSCOC 2020 of relevance to COVID-19. Mr. Satya, please.
Thank you, Colin. Thank you, MC. Good morning, everyone. Hope all of you are keeping well. In the course of my session, I will be covering three aspects. First, I will cover a case study concerning a claim by a contractor in the wake of COVID-19 and how that claim was resolved. Next, I will briefly touch on the assessor determination process under the COVID-19 Act. And third, I will look to the future of construction contracts in the wake of COVID-19. Now, for the case study, the facts are fairly uncomplicated, fairly straightforward, and these are facts that most of you would be familiar with, either because you have faced similar situation or facing situations like this. So what happened in this case was there was a contract between the employer and the contractor for fairly major civil works, the PSSCOC Design and Build 2014. And in this project, even before COVID-19 happened, the contractor's progress was already behind schedule. And even if the contractor were to accelerate, in all likelihood, the contractor is probably going to miss the completion date and is going to face liquidated damages. And the delay had already occurred even. And another aspect of this case was that the contractor is one of those, he doesn't really put in any claim. So there was no claim for extension of time. There was no claim for loss and expense before COVID-19. The contractor never really wrote many letters. A lot of things were done verbally. And then COVID-19 happened. In the wake of COVID-19, in the wake of all the circuit breaker measures that were announced, as well as the labor and material disruptions, the contractor's approach changed completely. The contractor submitted a slew of claims to the employer. These were claims for extension of time, and there were claims for cost relief, such as loss and expense. And all these claims referred to and relied on COVID-19 as the justification for the claims. And the claims were also very well drafted. There were a lot of legal terms, a lot of technical and contractual terms. And this was very different from how the contractor was communicating with the employer, prior to COVID-19. And in addition to making these contractual claims, the contractor also submitted a notification for relief under the COVID-19 Act. So this was what happened in the course of the project. The employer was very concerned in this situation. And these were some of the employer's key concerns. First, the employer was concerned, is this contractor actually preparing for war? Because on the face of it, it seemed as if the contractor already had lawyers on board or claims consultants on board, creating a paper trail with a lot of claims. And this was an attitude and an approach that was very different with the contractor pre-COVID-19. Next, the employer was concerned was, look, as I mentioned, there was a historical delay even before COVID-19. So the employer thought, look, is the contractor trying to be very opportunistic and trying to rely on COVID-19 to wash his hands and absorb responsibility for all of these historical delays, which had nothing to do with COVID-19? Next, the employer was concerned about, is the contractor actually contractually entitled to all this time and money that he's now claiming? Because many of you will be familiar with the PSSCOC. Even in the context of force majeure, if you rely on force majeure, it is a ground for extension of time under clause 14, but it is not a ground for a claim for loss and expense under the PSSCOC. So the employer was concerned, is this guy trying to be funny with me, trying to claim more than he's actually entitled? Next, the employer was concerned about what is this notification for relief under the COTMA? And because the employer was not familiar with the COVID-19 Act at that point in time, the employer was concerned over the risk and liability exposure that the employer may be facing in view of the notification for relief. So in summary, the employer was deeply concerned. And a lot of these concerns were driven by what I think distrust, sort of a distrust with the contractor. Is this guy trying to be opportunistic? What is the position going to be if this dispute doesn't get resolved? So those were the employer's concerns. On the contractor side, I think the concerns were two-pronged. The first and principal concern from the contractor's perspective was this. Look, when I priced for this job, there was no COVID-19. So at the time of tender, I didn't price for any epidemic, pandemic, let alone COVID-19. When I committed to the completion date, I prepared my schedule and my construction program and my procurement on the basis that there is no epidemic or pandemic that is going to disrupt and delay my ability to progress with the works. And the second concern was this. looking at the impact of COVID-19, both time and cost, what would have been a profitable project for the contractor was now going to be a loss-making project for the contractor. And without additional money and additional time, the contractor is not going to be able to complete the job. So if you look at the employer's concerns and the contractor's concerns as a whole, you realize that they are diametrically opposite. They're competing. They are sort of on the opposite ends of the room. So what then happened? Sensibly, they met. On the face of the notification for relief, both the employer and the contractor met. There were many meetings. The initial meetings, there was some banging of tables and raised voices. But the more they spoke, they realized that even though they had, each of them had their own individual interests and concerns, they had actually shared many common interests and common concerns. Now, what are these shared concerns? First, both parties agreed that they actually did not want to fight. They agreed that they should channel their time, their costs, and their resources towards the project and getting the project completed, rather than sitting in the lawyer's office and spending money preparing for an arbitration or adjudication. So they were in agreement on that. Next, they also agreed that it was in neither party's interest for the contractor to go into financial difficulties, because obviously for the contractor, he doesn't want to go into financial difficulties. And from the employer's perspective, if the contractor had financial difficulties, subcontractors are not going to get paid, suppliers are not going to get paid, procurement will be affected, the project is not going to move, and if the project doesn't move, that is not in the employer's interest. So they shared that concern. Next, they also agreed that the quality of the deliverables will not want to be compromised. From the employer's perspective, they don't want to end up with a defective project. And from the contractor's perspective, they also neither wanted to affect the quality of the deliverables. And I say that for two reasons. First, from a reputational perspective, the contractor didn't want to have a reputation as the contractor with shoddy workmanship, especially on a public project. And the next concern, and I think many of the contractors amongst you will agree with me, from a contractor's perspective, they don't want to stay on a job longer than it's necessary. They want to achieve completion, grab that completion certificate, comply with the defects liability obligations, demobilize from the project, and remobilize to the next job. Because from a contractor's perspective, if they stay on a job or keep having to go back to a job to rectify defects, they're not going to get paid for it, right? So if there's no money in it for them, why put in resources for doing that job? So they agreed that quality of delivery should not be compromised. And the next is, of course, they didn't want to take the risk and uncertainty of engaging in formal legal proceedings, whether it is an adjudication or an arbitration or even an assessor determination, which I'll touch on briefly later. The reason is because when you negotiate a settlement with the other party, the outcome is really in your control. You can either agree or you disagree. And even if the outcome is not the best outcome that you want, you know what yourself you're getting into. As opposed to a situation like an arbitration, you're really leaving the hands, your commercial situation in the hands of a third party to decide, and that decision could very well be unfavorable. So that is a big element of risk. So in view of all of these shared concerns, after much negotiation, they could actually agree. They could agree on how to move the project forward, and they entered into a supplemental agreement to record their agreement. Some of the key terms in this supplemental agreement was, first, they agreed on the extension to the time for completion, and they agreed to certain cost adjustments to be made to the contract price in order to ensure that the contractor has sufficient cash flow to continue with the project. And they didn't stop there. The employer also wanted guarantee that the subcontractors and the suppliers will also get paid, because the employer didn't want a situation where whatever money that is being paid goes into a little black hole, and if the subcontractor doesn't get paid, the project still doesn't move. So there were mechanisms to ensure that whatever money that is paid to the contractor, the money actually flows down to the subcontractors and the suppliers. So that's the first key aspect of the agreement. Next, in life, compromise is a two-way street. It is not a case where the contractor takes the time and takes the money and doesn't give anything in return. The contractor had also agreed to very committed deliverables. And this was very relevant in the context of COVID-19, because now that a lot of projects, not just in Singapore, but worldwide, are sort of restarting and resuming, there is a real mad scramble for resources, because every project is competing for resources, construction materials on a global basis. So the employer was concerned, will the contractor be able to procure and secure whatever that is needed to the project, or is he sort of back in the line with the supplier to get those deliverables? So the employer insisted that the contractor do a bit of due diligence and homework to make sure that they are able to secure whatever that is needed to complete the project by the committed extended completion date. And next, they also agreed on more enhanced project monitoring. So they agreed to work closer together on the project to make sure that every step of the way it is closely monitored. If any activity slips behind the agreed program, there will immediately be measures, mitigation measures that we put in place to catch up on the delay, so that this close monitoring will ensure that the extended completion date is not missed. So eventually they agreed on all of these terms. Both sides were reasonably happy and they signed up to a settlement agreement. Now the project, I think, is still ongoing. Has there been any problems? I don't think so. The reason I say this is because no one has called me to complain. So as the lawyer, this is one of those cases where no news is actually good news. So that's the case study. Next, moving on to the second part, which is the assessor determination process. What I've done, sorry, I should have said this earlier. These slides, don't worry about trying to write down everything that's on the slide available to you. What I've done in this slide and the next is for you as a practical guide, the individual steps that are involved in a assessor determination under the COVID-19 Act, and range in the sequence that need to be undertaken by each party. So hopefully that gives some practical guidance to you. And if I were to give some general comments on the determination process and tie it back to the real push for amicable settlement, I will make the following observations. First, you need to be mindful that there's an expiry date by which you need to apply for assessor determination. That expiry date is the 19th of December 2020. I think it is a good move on the part of the legislature to give parties a reasonably long expiry date before they need to apply for assessor determination. The reason I say this is because if, let's say, the deadline is within 7 days or 14 days of the issuance of the notification for relief, what parties will do is they won't bother to try to talk because they will be focused on trying to fight the assessor determination. So by giving parties the flexibility and comfort of a longer long stop date, it encourages parties to try to focus on trying to reach an amicable settlement. And only if they really can't, despite their best efforts, will they then refer to assessor determination. The next feature is it is final and binding, the assessor's determination. Why this is important is because I had previously mentioned the risk of an unfavorable outcome. So if the outcome in the assessor determination is against you, you are stuck with it, right? Unlike, for example, court proceedings where you can go before the High Court. If you disagree with the High Court, you can take it up to the Court of Appeal. An assessor's determination is final and binding. And this is, again, important because Colin mentioned that the process is free, no cost. In life, when things are free, it's good to try, but assessor determination may not be something that you want to quickly jump into, because if the outcome is unfavorable to you, you're really stuck with it. So really do give amicable settlement a shot. Next, a lot of times direct negotiations may not necessarily work. That doesn't mean that you need to jump to assessor determination immediately. Another option that many of you can consider is mediation as a possibility. Kudos to the Singapore International Mediation Center. They have come up with a mediation protocol geared towards COVID-19. And this is important because these mediations are actually quite low cost. They're not free, unlike assessor determination. There's a cost, but it's quite a low cost. And they will be able to organize the mediation very, very quickly, because they're also mindful of the deadline for parties to go for an assessor determination. So if direct negotiations fail, please do consider mediation as an option, because a neutral evaluator, a neutral party like a mediator may be able to bring parties closer together. So these are sort of the general features of the assessor determination process. I mentioned, 3 slides setting out step by step. I've set up these in these 3 slides. Moving on to the final point. The final point is really on the future of construction contracts. Now that we have COVID-19, I think construction contracting tendering may not necessarily be the same as what it was pre-COVID-19. What a lot of us are familiar with and used to is what I call the traditional contracting, whether it's the PSS-COC or the SIA or the REDAS form of contract. How traditional contracts operate is there are a set of obligations that a contractor needs to perform. If the contractor breaches any of these obligations, the employer will then enforce a remedy against those breaches. The contractor will make claims, and these claims are assessed from a very legal and contractual perspective. They're either accepted or they're rejected. And what traditional contracting does, it promotes a very adversarial behavior. It becomes a contractor versus employer kind of attitude. I claim, you get rejected, I take you to arbitration and we fight. So that may not necessarily always be a very healthy way of undertaking construction projects. There is also an alternative to traditional contracting, which is what is called collaborative contracting. Collaborative contracting is popular in Europe and different parts of Asia. It is particularly used in public sector projects in places like Hong Kong. There are certain forms of contract, like the new engineering contract, which is a UK form of contract that adopts the collaborative contracting. What is collaborative contracting is really both the employer, the contractor, the consultant team, all of them working together rather than in a rather adversarial behavior. They sort of work together towards pursuing the interests of the project. So rather than focusing on contractors' interests and employers' interests, there are a set of project interests. All of them work together. There are various mechanisms in the contract to bring parties together to sort of work together. And why do I say this, refer to collaborative contracting in the context of a COVID-19 talk is this. I've done several talks on collaborative contracting. Collaborative contracting will only work if the parties have the right mindset. Because you can have a very wonderfully drafted contract. If parties refuse to collaborate, a collaborative contracting will not work. So the mindset is very, very important. And looking at having advice on a number of projects, claims, COVID-19, and trying to do amicable settlement between parties, the positive effect of COVID-19 is that parties now are really talking a lot more. They're having a lot more open, candid discussions on how to resolve the problems that everyone is facing. And that open discussion is actually healthy towards collaborative contracting, right? So I think that's a positive step towards collaborative contracting. BCA has rolled out an option module under the PSS-EOC to introduce collaborative contracting. It hasn't been rolled out in private sector projects as yet, I think. An initial large project that's been rolled out, I think, is the JTC's Punggol Digital District project. So perhaps with this new approach that contracting parties are having in terms of trying to talk to each other, trying to resolve differences, hopefully that's a good platform for collaborative contracting in Singapore, not just in the public sector, but in the private sector as well. So that, I think, is one positive future development in the post-COVID-19 world. The next change in COVID-19 that's sort of brought about by COVID-19 is this. BCA published the PSS-EOC 2020 fairly recently. There are a number of changes that the 2020 form has made to the 2014 form. Some of these changes were actually motivated by COVID-19, and what are these? First, many of you will be familiar with the 2014 form. In the 2014 form, force majeure is actually not a defined term. So force majeure, the contract doesn't actually say what force majeure means. That sort of creates uncertainty over and arguments over what force majeure actually means. Next, epidemic and pandemic is not a ground for EOT under the 2014 form. So that's the 2014 form. The 2020 form introduces two significant amendments. First, force majeure event is actually defined. That is set out in clause 14.2a as an event which is beyond the contractor's reasonable control. Second, epidemics and pandemics is actually a ground for an extension of time. So it's an express ground for extension of time. For contractors, of course, that's good news because they are now entitled to additional grounds for EOT over and above what's already in the 2014 form. And a lot of contractors are really genuinely concerned about the effect of COVID-19 or similar epidemics or pandemics for future tenders and future projects. Hopefully, with these new additional grounds, you will assuage some of their concerns. And I also see a benefit to employers as well. The reason is because, like I said, a lot of contractors are concerned with COVID-19. A lot of contractors are concerned about future epidemics, not COVID-19, but something else. What if there's a future pandemic or epidemic in the course of their future projects and how that will impact them? And what contractors will tend to do is that if you don't take that risk away from them, they're going to price for that risk, right? Because they will say, okay, what happens if there's a COVID-20 or whatever? I need to price some sort of a premium for that kind of risk because I'm assuming that risk. With these new additional grounds for EOT under the 2020 form, contractors don't need to price for that risk. And the thing with risk is this, it may or may not materialize. If it does not materialize, it's actually a windfall for the contractor. It's a windfall because the contractor has already priced for it. He will still get paid his contract sum even though the risk didn't materialize. So with this sort of adjustment and reallocation of the risk of force majeure and epidemic and pandemic, Hopefully that leads to more competitive pricing in your public sector tenders, and more competitive tendering, I think, is a better use of taxpayers' monies for public sector projects. Okay, with that, I'm at the end of my session. I think we can move on to the Q&A segment for today's session.
Thank you, Mr. Satya. Right now, we'll move on to the Q&A session. You may raise your question by clicking the raise hand or type in your questions under the Q&A button on your screen. Over to you, Mr. Koo and Suming.
Hi, thank you, MC. All right, thank you both speakers for their insightful sharing on the respective topic. And of course, I totally agree that we are all facing a challenging and unprecedented time. While I think it's important that we look at how we can work together amicably. And of course, it's also, I think it's raised by, shared by Satya, that it's also timely, looking ahead that for our industry to look at kind of a paradigm shift to adopt more collaborative approach instead of just adversary moving forward. All right, so before we move into the Q&A proper, I'd like to invite both our panelists, Architect Chan Kok Wei and Mr. Kenneth Lu, to just share their quick thoughts. Kok Wei, over to you.
Thank you, Zabun. I also wish to thank SISV and BCA to invite me in this webinar. I think it is timely that we need an update after the restart of work since early June, and also I believe the consultant and the contractor also experienced some form of slow start due to various reasons. So I think this is a webinar to give us some update and also prepare us further for the coming months that how do we cope with these situations. So that's all I'd like to say. Thank you, and I hand over to Kenneth.
Hi everyone, morning. Thanks SISV and BCA for inviting me. I think we are all in unprecedented times. Officially the industry has supposed to be started in June, but in actual fact, I think a lot of us realize that the quantum of work that really starts is actually not desirable. I think that will actually lead to a lot of issues that we need to resolve. I think today's webinar is timely to address these sort of issues. I think it's also a situation whereby none of us have actually experienced it. It's something new to everybody. I think it's timely that all of us come together to work towards resolution and to bring the industry forward. The issue also is that the time is also changing. Everything is evolving. This process needs to be continued. I guess, like what Satya said, I think it's timely that all of us come together. Thanks.
Right. Thanks both Kok Wei and Kenneth. I certainly agree. I think this is the time over the last few months. I think, of course, the respective professional institute, which forms the construction industry joint committee, the 9 associations, have been working very closely with BCA over the last few months. And probably we have the most meeting as compared to many years ago that we only meet a couple of months per year. So I think there are a lot of interactions, and then also getting our feedback from the respective members and so on and so forth. Right, so before I move on, we have also received some questions that came in prior to the webinar itself. And I think we also formulated some quick answer to it. So I'll now hand over to Ms. Lim Pui Shan of BCA Procurement Policy Department to just quickly run us through some of these questions. Yeah, Pui Shan, over to you.
Hello, hi, this is Pesha from BCA. I'll just run through the questions now. Okay, the question 1 is, how do we deal with stopwork order issued by MOH or BCA for new COVID positive cases at site in terms of EOT and loss and expense? Okay, for this, any application for EOT and L&E has to be assessed according to specific provisions, contract provisions. So you have to establish whether the reason for the stopwork order falls under any grounds for which EOT or L&E may be granted under the contract. So in this specific case, if the stop work orders are issued due to breaches of safe management measures, then this should be the responsibility of the contractors. Okay. The next question is, how should the additional time and cost for the bi-monthly swab test be looked at? And will the cost be paid by contractor or client when the government grant has ceased? So I think everyone is aware that the government has waived the cost of swab tests for construction works until March next year. So any other additional costs and time after this would have to be assessed according to the specific contract provisions. So question 3, for private projects, who will bear the cost for temporary accoms? I'd just like to clarify that it is actually not necessary to erect temporary accommodation to meet the safe accom requirements, and cohorting of workers within the purpose-built dorm is also acceptable. So on 10 August, BCA has announced that the 10 addresses rule for the contracting workforce has been temporarily suspended to allow quicker restart. So to help the construction firms defray costs in procuring additional material and equipment in order to comply with the COVID-safe worksite requirements, the government has set up the construction restart booster. So contractors may also consider tapping on the government's temporary bridging loan program to secure low interest loans, and the application may be made through preferred local banks. Next, they are asking whether is there any subsidy from government since we have to rent more rooms to segregate workforce for different projects. The answer is similar to question 3, where you can use the construction restart booster, which was provided to help construction firms to defray the cost in complying with the COVID-safe measures. Next question. So, okay, the last question is, will there be any co-sharing on the additional costs borne by contractors? Again, it depends on the specific contract provisions, but for public sector projects, we have taken the lead to co-share on an ex-gratia basis 50% of the prolongation cost or delays due to the circuit breaker and the control restart, as well as the loss of productivity due to compliance with the COVID-safe requirements. So the co-sharing will be up to 0.2% of the contract sum per month of delay, capped at 1.8% of the contract sum. So further details can be found in our circular, which is uploaded in our website. So BCA has also worked with the radars to encourage developers undertaking private sector projects to lend their support and similarly practice such shared responsibility. Back to you, Subun.
Yeah, hi, thanks, Prishan. All right, so next I'll move on to probably cover off some of the questions, and thanks for the question that's coming in through the typing in the questions. So I think the first few questions I'm looking at more from the COPMA itself, was asking for projects in the design stage, how to claim for compensation if designer works at home. Would there be any quick response from anyone about Colin, yourself, or Prishan? I think it's more, asking pertaining to more design work instead. Yeah. Prishan, any quick response on that?
Sorry, I didn't get your question.
Okay, the question is actually asking for projects that's in design stage, how to claim for compensation if designers work at home. But it appears to suggest that it's relating to designer works itself. Yeah.
Okay, currently for consultants, yeah, I guess they're referring to the consultancy works. So
two possibility I suspect. One could be consultancy work, and then the other one, not exactly sure whether we're referring to designer. Are they referring to in-house designer? I do understand that there's some job that's design and built, and that could have been designer that is in-house. Yeah, it could be from two aspects. Yeah.
I see. Anyway, in terms of design, the payment structure is based on milestone. milestone payment. So usually they will get paid according to when they have achieved that stage of progress. So let's say if they continue to work at home and they continue to achieve the milestone, then they can get paid accordingly. So I think the same will apply to even in-house designers which are designing under the contractors, because I mean, so long as there's work, they will continue to get paid.
Zubun, if I may add to question.
Yeah, please. Please
so you're right that it could either be arising from a design consultancy contract, or it could arise from a design and build contract. Typically for consultancy contract, there is no liquidated damages or completion date, typically, right?
Yep.
So whenever people talk about extension of time, it is only relevant when there's a completion date, so that you apply for EOT, so there's no exposure for LDs. But if there is no LD clause, there's no EOT mechanism in the consultancy contract, the delayed impact is not actually relevant. So that's the first part of it for the consultancy contract.
Right.
For your design and build contracts, of course, it's different because there's completion date, LDs, and EOT. This really depends on two things. First, what is the D&B contractor's entitlement to EOT under the contract? So it depends on the terms of the contract. Second, as with most EOT clauses in standard form contracts, you need to show cause and effect. You can't just say this event happened, therefore I'm entitled to EOT. You also need to show the effect that the event had on your progress. So to the extent that the design works could have been done at home, so the fact that there was circuit breaker measure has got no impact, then you are going to have a problem proving the effect. But if you have a situation where there is on-site work and design work taking place simultaneously, then you'll be able to show the effect of the circuit breaker measures.
Right. Thanks, Satya. Yeah, for adding on as well. Okay, let's move on. Also a question pertaining to notification of relief, which I believe we may be covered, but probably there are a few questions around it. It says that if the notification of relief is not served through the MinLaw online form, but by issuing of letter, will it be valid actually? Maybe Colin would like to just clarify that part.
Yes, there are certain, it will still be valid, subject to it complying with certain rules. It should be served. Through prepaid registered post. So you can of course put it under a cover letter or anything like that. That's fine. But as long as you do it through the modes which are specified in the regulations, it will be valid.
Okay, thanks, Colin. So I think you stressed that I think it's still valid, but I think it's important that they got to make sure that it's prepaid registered post into the relevant address and things like that. Yeah.
If I may add, I think there are some questions pertaining to, is there a due date that this notification has to be submitted as well? I think there are quite a number of questions.
Oh yeah, quite a number of questions around it.
Yeah, perhaps if we can clarify these procedural things up front, it will help the audience.
All right, yeah.
Well, I mean, there are two aspects to this. First of all, there is the date on which the relief ends, which currently is 19th of October. So of course, we serve it after that, it's quite pointless. The second thing is that, which is a practical aspect, which is if you should serve it before anything happens. For instance, if let's say the lawyer has already called on the performance board, then it's too late. So this should be anticipatory. Before something happens, put in your notification for review. So I think those are the 2 points which you should consider. But if you ask me, is there a deadline? Then I would say it's the end of the prescribed period, which currently stands at 19th October.
Yeah, if I could just share one practical perspective from the case study. Because I think relationship is very important. We are all humans, emotions are very important. I think what contractors may consider doing is, I mean, they need to put in a notification for relief to protect their position, but sometimes it may be helpful to just give the employers and the consultant a heads up. Pick up the phone, call them and say, okay, look, I'm planning on doing this. I'm giving you a heads up. I'm not here to fight with you. I want to resolve things amicably with you. I'm just sending you an advance copy. Please take a look at it. Whenever you're free, let me know. Let's have a chat and let's try to resolve it. So you at least manage the human interaction and the emotional side of things, which I think is very, very important, if not more important than the contractual and legal aspects of things.
Satya, thanks. Certainly agree with you more than 100%. I think it's very important. I think when coming to especially this moment, working together. I think after all, is every of us are none of us are spared from this whole situation. Yeah, working together and find amicable outcome is certainly a win-win for everyone. Instead of getting us more stressed out through other means,
And I know it's a bit ironic coming from me as the lawyer, because people might say if everybody settled lawyer bossingly, right? But I mean, I really see the benefit of amicable settlement, because I mean, the reality is this: none of us anticipated it. It's a difficult situation.
Sure.
If we don't work together, we're just going to make the problem worse.
Sure. Satya, it's very, very clear that you're part of the industry. Yeah, so you use in the industry, you understand the industry. So that's certainly a good point. I guess there's many other fellow legals, practitioner that is also working very closely with everyone. Hopefully will share the view as well. Yep. Okay, let's probably move on. There's a question around how subcontractors able to claim for prolongation costs due to COVID-19. Yeah, so I think it's also about whether they are also allowed to serve the relief. And then the other part is a prolongation, is a bit on the measures itself. Colleen, I think first point on the subcontractor, we want to just cover that. I don't think it's just limited to just main contractor per se for the COVID Temporary Measure Act, right? Yeah.
Yes, you're right. It doesn't cover just the main contractor. The subcontractor can also seek leave. I'm not sure how it relates to the question though, which is how to claim costs, the prolongation costs. I mean, the Act, as I'll explain, gives the main relief is the temporary protection from legal action. So it's a defensive measure. Also, then there is also the second aspect of it, which is the defense against claims for breach or delay. So in terms of claiming prolongation costs, it's not something which you can achieve through the Act or through our assessors, unfortunately.
All right.
That's right.
Just a question. Sorry.
Prolongation cost claims are determined in accordance with the contract. So the COVID-19 Act has got nothing to do with prolongation claims. It's got nothing to do with extension of time. All of that is purely determined by the terms of the contract. So, which is why, going back to the case study, what the contractor did in that case was he put in a notification for relief to claim relief against LDs, which Colin touched on in his segment. On top of that, there was still a contractual claim for EOT and loss and expense, because you need to do that separately in tandem.
All right. Yeah. Okay, there's a question a little long pertaining to the Act itself. If the contractor submitted a notice of relief with regards to the extension of time, concurrently, contractor has submitted notice of claim to us, basically is saying us, I believe is bracket as authority. So I suspect it could be a GPE. Yeah, we administer the claim and reply to the contractor pending his substantiation for evaluation, which I believe is pertaining to the contract notice of claim. Will MinLaw still take action on the contractor's claim under the notice of relief? So it's like probably the contractor will go on a concurrent approach, serving the notice of relief as well as serving a notice of claim under the contract. Yeah.
Sorry, Colin, you wanted to?
Yep. Colin, you want to cover that, or yeah, there's two parts to it, lah. Yeah.
So I mean, I don't quite understand the facts fully. Maybe Satya can jump in and I'll stand corrected. But what I seem to understand is that the contractor submitted the notice of relief to the employer, and then in parallel has submitted a notice of claim to someone else. But well, look, the notification for relief actually is really a moratorium, right? And if it's to give breathing space for the contractor to do what is necessary to sort out, to get the reliefs, to apply for reliefs, to enter into negotiations, and to sort out his affairs with the other contracting parties. So after he does the notification for relief, we expect that the contractor should go and do other things. Okay, it doesn't stop you from doing any of these things at all. Now, when would you have to come back to MinLaw? Actually, he doesn't have to. The contractor doesn't have to come back to MinLaw. It is really the other party who has received the notification for relief. If the other party believes that, hey, this notification for relief is invalid, this person actually, I mean, touching on like Satya's case, maybe it was a recalcitrant contractor. The delay or the breaches have nothing to do with COVID whatsoever. The employer might say, no, I want to challenge it, I want to be able to enforce my rights. Then the other party will come back, and then the assessors will deal with it. Yeah, so that's what I have to say about it. Maybe Satya has the insights.
No, I have nothing to add, Colin. Thanks.
Okay, thanks, Bobby. I think you're right. I think Colin, you mentioned that both the notice of relief as well as the claim, in that respect, I would suspect that it should be served to the employer under the contract. Yeah, then because there's a subsequent part that says that will MinLaw still take action. Unless, I'm just thinking a lot, unless you're saying that after submitting the notice of relief, and then there's re-determination, and then at the end, they are not quite pleased with that, and then probably they escalate to MinLaw through the I'm just suspecting it may mean escalating for the assessor determination. Yeah, in that respect, yeah, from that perspective, then which means actually they have escalated. Would MinLaw still look into that in terms of assessing, assigning an assessor to assess it?
Well, actually, the entire process is quite light touch from us, very little involvement. Once you put in the notification, once you serve the notification for relief, the law says that the other party cannot do certain things. So if the other party does it, it's actually an offense under the Act. You can be charged for it. So you really shouldn't do it. And any actions which are done in breach of those prohibited, any of those prohibited actions, if you take it, they're invalid anyway.
Sure.
So there is no need to come back to MinLaw to say, hey, this and that is happening. Really, if let's say if you serve the notification for relief, the other party starts a court action, for instance, in breach of the notification for relief, just go to court and say, I have already served a notification for relief, and the courts will stay the action, for example. Okay, I saw another question about performance bonds. So the notification for relief, if let's say you want to get protection from prevent a call on the performance bond, the notification for relief must also be served on the bank or the insurer who issued the performance bond. It's actually inside the template for filling up the notification for relief. We ask you who are the other parties, and so you should fill up all these things and it will be served to the relevant parties. So once you have done that, you really don't have to come back to MinLaw. As I've said, the only time when you come back to MinLaw is if the other party disagrees that you qualify for the relief in the first place, meaning that, for instance, you're not one of the scheduled contracts, right? Or the contract was entered into after 25th March, or the obligations before 1st October. So just to give you an example, one of the cases we received for assessment related to a contract which actually was finished a long time ago. And then there were delays in payments. So the parties entered into a settlement agreement in 2019 to try and reschedule those payments and to have a discount. So, but when COVID hit, the employer couldn't, or the main contractor in that case, couldn't pay, like there was cash flow issues, and said, oh, because of COVID, I can't pay according to this settlement agreement that was reached in 2019. So in that case, for multiple reasons, first of all, the contract is for an obligation to pay in 2019, so it's before 1st February 2020, it doesn't apply. Second of all, the payment obligation is actually not under a construction contract, it's under a settlement agreement, right? So for those reasons, that assessment was, I mean, the subcontractor in that case correctly refuted and disputed the notification for relief. So those are the cases which will come to me. Other times you don't really have to come back to us.
Right, thanks, Colin. Yeah, just before I move on to the next part of the Q&A, just want to check with Kok Wai and also Kenneth, we got anything to actually add on pertaining to the Act itself?
Oh, thanks, Zabon. I have one question here. I think maybe addressed to Colin. Then this is a temporary relief. At this moment is up to 6 months, which is up to 19 October 20. So my question is that would there be any prospect to extend it? I know it's up to 1 year, but at this moment the other 6 months has not been announced or effected yet. But so now, looking at the restart, actually, just like Kenneth just now said, that the restart is very slow, the momentum is slow. So we foresee that the next 2 months, the work will not be able to go back to 80–90% of the productivity. So in this regard, 19 October is just about 2 months from now. So would Min's Law or BCA consider to look into this aspect of extending the temporary relief to a longer period? Thank you.
Thanks, Kawai. Yeah, I think there's also some question around this extension as well. Yeah, thanks for raising that. Yeah.
Yeah, well, today I'm not prepared to make any announcements. Anyway, it's not for me to announce. So the minister has the power to extend or prescribe the period. It is something we are studying. We are looking at it very carefully. And once we have done that, and once we are ready, we will make the necessary announcement. Hopefully, way before 19th of October, so you actually know what's coming. I just wanted to share that in looking at whether or not to extend the period, there are multiple considerations. One is, of course, we are intervening in private arrangements, which is something I highlighted, and it's not something we do lightly. Because ultimately, if the market can sort out these things itself, it's better, right? Because the market knows how to resolve things better than any of us sitting here in this office can do. So that's one aspect of it. But of course, the other aspect of it is whether the sector needs this addition, an extension of the relief. So if you don't mind, I'll throw back the question. Do you think that the period should be extended?
Okay, since I raised the question, maybe I attempt to answer it. I think that there is a necessity because looking at the current situation, the restart is not as promising as what all of us see it. I think at least from my profession point of view, we look at the contractors restart at this moment that they are not up to speed yet. So even give an example for myself, in my office, I think it's only about 30% of our construction work restarted with some activity. The rest is still quite standstill at this moment. So that is a concern that I have in mind. That's why I take this opportunity to raise. Thank you.
If I may just add one point, I fully agree with Colin that it is a very, very difficult decision to make. Thankfully, I'm not making that decision. Because there are many concerns and considerations. Because I know one way, some people will be looking at contractors, subcontractors, and all of the downstream obligations. But one must also realize that you also have the private sector developers. And private sector developers don't have similar reliefs in their upstream contracts to their end users and their purchasers. And a lot of the COVID-19 relief has already had adverse impact on them. And if you extend it, that's going to affect them as well. So there are a lot of competing interests that needs to be balanced. And I'm sure MinLaw will carefully consider everything and come to the decision that is best for Singapore and its people.
Right, thanks. Kenneth, you have any
Yeah, I just have a comment to make. I think when the CODMA first came in place, it was very early in the pandemic. I think we have gone through many months. I think situation has changed. Perhaps maybe we need to review and reconsider because there are certain things. For example, during the CB period, for all of us, time and cost are the two main things. Time is definitely something that perhaps maybe we can look at it in a as is. There's no activity at all. So instead of where I'm coming from, instead of perhaps maybe leave it to the parties to negotiate and talk, perhaps give us some direction that okay, between April to June, absolutely no activity. Perhaps that part is a blanket or something like that. That perhaps maybe we can, industry can work towards. Perhaps maybe BCA or MinLaw can actually give some guidelines towards to that effect.
Right, thanks, Kenneth. I'll just move on to other questions. I think we're looking at the interest of time as well. There's also a question because I understand Satya also shared about in the case study that as a good practice, at the end, when the generally coming together to have an amicable understanding agreement among the party. And you also brought up the point about supplemental agreement, where at least kind of document some of these what the terms been agreed. So there's actually a question around, is supplemental agreement possible under PSS-CoC, which I believe, since the talk is about public sector contract. So I guess the question is around, are they allowed to do a supplemental agreement if it's a public sector contract? Yeah.
When you say whether it's allowed, I think that is largely the internal decision of the government procurement entity in terms of whether there are any constraints or restrictions on entering into a supplemental agreement. I can't give a blanket answer to that because individual organizations, their concerns and considerations may be different. The reason why I think a supplemental agreement is important is because you may negotiate things for very long. Both parties need to be clear on what they have agreed. And putting it in writing is important because it brings clarity and certainty for both parties. And from a contractor's perspective, there may be a withdrawal of the notification for relief as a result of a settlement reach. You don't want to end up in a situation where the contractor withdraws the notification for relief, and then later on LDs are imposed because the agreement was not documented properly. So I think it's good practice to document it properly. It's certainty and clarity for both parties. And even from the perspective of administering the contract, because a lot of times your contract administrator, your superintending officer may be third-party consultants. They may not be directly involved in the negotiations. But once you document it and you share a copy with the consultant team, they also know what are the modified terms to the contract so the contract can be administered accordingly.
Right. Thanks, Satya. How about Puishan or Colin, anything to add from the public sector or from the, because you're looking at more the PSS-CoC itself, yeah.
So there's nothing other I'll add that would prevent it. Nothing to add.
Okay. All right. Thanks.
For the public sector, actually, for any other ex gratia or additional agreement, they can actually effect supplementary agreement between the parties. Yeah.
Puishan, do we, I mean, at the GPE level, do they need to seek any kind of approval, or is it actually the authority within the respective GPE itself?
For any supplementary agreement, yes, they will need to seek authority approval within their own authority.
Okay, within the GPE itself lah.
Yeah, correct. Usually.
Right. Okay, usually lah. Okay, thanks. So I mean, long and short, the answer is possible. Yeah, it's possible. Yeah, right. One more question is also on the ex gratia co-sharing of the prolongation cost due to COVID-19, which currently is applied to public sector construction works referred to building, civil engineering, and additional A&A works. How about direct contracts awarded by LTA for site-wide contracts for MRT projects? Any quick thoughts on Puishan, your side? Pertaining to, I think, more on the LTA contract itself, yeah. Which is, I guess, is also a public sector contract, yeah.
Yeah, okay, for very specific contracts that they are on the gray areas, right? Actually, we encourage the GPs to come to us and then we can discuss whether or not the prolongation ex gratia payment can apply. So in this case, I think LTA could have come to us. Yep.
All right, understand. All right, so in terms of time, I probably, I mean, there are still questions that is still coming in, and I think at the end, we will probably collate it and also have some response. That's what I understand, right, Sumi?
Yeah.
Some, yeah.
So all the questions that we received through today's webinar, we won't be able to answer all of them. I think we have grouped some of them and we've tried to answer them either online or verbally. The rest of it, we will continue to group all of them and to seek answers from the relevant parties. And we'll publish this on BCAA's website probably in a week's time. So you can log in again to look for answers to some of the other questions, including questions that are not directly related to today's webinar. I note that there are some questions on restart criteria, accommodation requirements and things like that as well. So those will also be answered. We still have a bit of time, about 10 minutes. Perhaps we can start taking in some of the live questions through some of the participants who have raised their hands. We can, MC, can we pass it to you?
Yes, co-chairs, the first one in line is Mr. Dean Muhammad. We have issued you the right to unmute yourself. Should you try to speak? Thanks.
Yeah, Yeah, thank you for giving me an opportunity to ask it. Actually, my query is actually when we actually sorry, just a minute. Okay, notification for the relief is has to be a company or individual projects. So the main, as we having a multiple of public sector project, so we need to be submit a relief for every individual project or company itself. Just one application will do for all the projects. Then secondly, the prolongation cost, is it can be applicable only for public sector or it will be applicable for private sector project also? That's all. Thank you.
All right, thanks. So to sum up, I think your first question is around whether if you have a portfolio of projects, when you submit the notice of relief, can you submit as one relief as compared to you need to submit multiple reliefs itself? I think my quick thoughts is actually it depends on whether it's a multiple packages under one contract, or are you talking about different contract itself lah? If I'm not wrong, I mean Satya and Colin can add on. I believe you're referring to the individual contract. We're referring to the notice itself, just like when you're serving a notice of claim and things like that. Just over to Colin and Satya. Yep.
Colin, shall I have a go at it? Thanks, Dean, for your questions. On your first question, it is on a contract-specific basis because each notification for relief and what you're looking for is based on your individual contracts. You typically will not consolidate many contracts across different projects in one notification for relief. That's your first question. On your second question, whether it applies to both public and private sector, as it stands, it only applies to public sector. Based on what I've read online on BCA's announcements, I think they're trying to speak to REDAS to encourage private sector developers to adopt some sort of a co-sharing arrangement as well. So kudos to BCA for that. One thing I can share with you, I was involved recently on a private sector project where they were trying to negotiate some sort of a cost-sharing arrangement. They couldn't actually agree on what that percentage would be. And eventually, they actually referred to BCA's formula on co-sharing arrangement for their private sector project as well, because both parties agreed that, you know, if it's from BCA, it must be sort of objective and fair to both parties. So they actually adopted that particular formula for the private sector project as an objective standard. So strictly speaking, it does not bind private sector parties, but parties may be encouraged to adopt a similar formula as an objective criteria on how they share the prolongation cost.
I have nothing to add to what Satya said.
Right, thanks, Colin. Yeah, MC, over back to you. Yeah.
Mr. Dean, is your question answered?
Yeah, thank you. I got it. Thank you so much.
Thanks.
You.
Next up, we have Mr. Chong Zhimin. Mr. Chong, can you unmute yourself? Thanks. We see that you have unmuted. Could you try to speak?
Hello, Panelist?
Yes.
Yes, we can hear you.
Great. Hi. It's just a clarification to the earlier question that I posted. Thanks, Colin and Satya, for the answer. But just to clarify further, so first, my contractor submitted his notice of claim to us, the GPE, and we have administered the claim. And we have said that we will evaluate subsequently after his substantiation. But however, it's only recently we received this notice of relief from the contractor as well without a heads up to us. So it was forwarded to our team, and we were caught pretty much on a blind side. So we are concerned whether main law will take action on this, or what's the repercussion effects on this notification against our notified claim procedures within our GP procedures? Yes.
Well, first of all, the Act doesn't stop you from doing anything until the notification for relief is served on you. So anything which you have done prior to that is entirely okay. But after you receive the notification for relief, you're only prevented from doing certain things. There's a fairly long and extensive list of things you cannot do, which is set out in Section 5.3 of the Act. So I suggest that you go look at that. I'm not entirely familiar with I'm not a construction lawyer, but I don't know what you mean by you have administered it. But if you have just studied the payment claim and looked at it and determined what he has to be paid, I don't see that as a prohibited action under the Act. But I think Satya will tell me that I totally misunderstood it.
Yeah, thanks, Colin. So Zubin, the case scenario that you mentioned is actually very analogous to my own case study. The situation is actually quite similar. So this is something that is important that everyone is clear on. The COVID-19 Act does not deal with extension of time claim, does not deal with loss and expense claim. The COVID-19 Act has nothing to do with it, and Assessor doesn't look at those issues, right? So which is why what the COVID-19 Act does in the specific context of delay is that there's relief against liquidated damages. So what the contractor has basically done is he's put in his usual contractual claim, by notifying claim for EOT and costs. And he's doing like a defense. I think what he's doing is more like a defensive action. If let's say the SO in your contract rejects the EOT claim, that means that the contractor is exposed to LDs. So the notification for relief is really a defensive action. Just in case the SO rejects the EOT, he uses the Act as a backup so that he's not exposed to LDs. So that's probably what I think the contractor is doing. How do you deal with it? My suggestion is to deal with it globally. Don't look at the contract claim and then deal with the contract claim separately and then deal with the notification for relief separately. I think they're all related. So one thing you can consider is, putting it all together, speak to the contractor to see whether you can reach a global settlement on the time and cost reliefs. And if you can reach a resolution, the notification for relief gets withdrawn. So there's no exposure under the Act. And then you record the agreement that you reach and then you can sort of move forward. So that's one way of trying to deal with it. Of course, the other way of trying to deal with it is to deal with it separately. So you get the SO to assess the EOT and the cost claim. And then on the notification for relief, if you disagree with the relief that the contractor is seeking, you can refer it to the assessor to determine. Why I don't encourage it is because, there's no consultation, there's no discussion, there's no collaboration. It is a very contractual way of looking at things. In this day and age, that may not necessarily be a good thing. So give commercial discussion a shot. I'm not saying that every case will settle. Of course, in every case, you have your difficult employer, you have your difficult contractor. Give it a shot. If it works out, good for you. If it doesn't work out, consider mediation. If that doesn't work out as well, then things will just need to take their natural course.
Thank you, Satya. Allow me to rattle on a bit more. What I caught on the earlier statement was that this notice of relief does not deal with EOT. And the best part of this whole notice of relief is they did submit this sort of a substantiation or a chain of events, and right on the starter, they're trying to request for an extension of time, specific number of days due to the circuit breaker and the extended period circuit breaker.
Yeah, the reason why they need to do it is this. Colin mentioned in one of his earlier slides, right? In order for the contractor to claim relief against LD, the contractor needs to show two things. First, the contractor needs to show that he's unable to perform contractual obligations. Next, he needs to show that the inability is because of COVID-19. So he needs to justify it. That may be the reason why the contractor goes into sort of a chronology of events to say when the delay occurred and how the delay is sort of linked to COVID-19. But if the contractor went to essentially putting in an EOT claim and a loss and expense claim in the notification for relief, what would probably happen is that if this thing goes to an assessor, the assessor is going to look at it and say, look, my role under the Act is to determine whether there's an inability to perform and whether it's linked to COVID-19. I don't have the power to determine extension of time. I don't have the power to determine loss and expense claim. I'm not going to decide all those things. I will only decide what is within my power.
Great. Thank you, Satya, for clarifying. I think it pretty much hit all the nails that we had in our doubts. Thank you so much.
Thank you for your question.
Yeah, thanks, Satya, for that. That's exactly how the Act is meant to work. The assessors will not determine the EOT nor whether you are entitled to liquidated damages. The notification for relief is really intended to spark a discussion between the contractor and employer or the subcontractor, and to give a temporary moratorium so that that discussion can take place. If you can resolve it, great. If it cannot be resolved, then the notification for relief entitles the party who served it to make that argument that he should not have to pay related damages later on in arbitration and
A long story short, so basically the GPE still holds the primary approach to handle this whole claim exercise. Unless all things collapses, then I would say the notice of relief and admin law the assessor will come into place, right?
Well, let me just clarify again. So if right now, having received this notification for relief, I think you can go and engage them, consider mediation and those other things which Satya highlighted. Yeah. But if for whatever reason you don't agree with the notification for relief, okay, if you think that the notification for relief doesn't apply, for instance, let's say the contract is made after 25th of March, right? Then you might want to come back to Min Law and ask the assessor to say, hey, this notification for relief is actually invalid. And then the notification for relief will be thrown out, put it that way. Then you will be subject to these things. So in very narrow circumstances, then is it necessary to come back?
Understood. Thank you, Colin. Thank you, Satya, for clarifying the doubts.
Thanks. Great. We have managed to answer your query. Probably move on to the next MC. The next.
Co-chairs, it's about time to wrap up. Do you want to take the one last question?
Yeah, probably we take one last question. Yeah.
Okay. It will be from Mr. To Seng Ka. Could you unmute yourself? Thanks. Mr. To, are you there?
Sorry. I think I pressed wrongly. No question.
Okay, no question. Then we'll move on to Yen Wang. Could you unmute yourself?
Sorry, no question. I think press wrong.
Okay. Perhaps one last question from Mr. Colin Kin.
Hi guys, this is to Kenneth. Good morning, Kenneth. I know contractors are bleeding at the moment, right? They're really suffering at the moment.
Yes.
And I can understand, and this is my concern: is a lot of the players might go under. Yeah, this is a real concern, and I think this is what's driving people to negotiate, to talk, yeah, because we have to, otherwise you're going to go under. But I'm thinking one step ahead, in terms of, because you're bleeding so badly, your liquidity, your cash flow, your gearing is all going to suffer, right? And these are critical criteria that we look for in future tenders, right? So there are big projects that are going to be coming up. And this issue of your financial strength is something that we assess as a quality criteria, yeah? And we give points for that quality criteria. Is this going to be a problem for members of SCAL?
Colin, I think it's the financial standing of not only the main contractors, the whole value chain is impacted in this whole pandemic. Perhaps I think maybe even the CRS criteria that perhaps maybe this is a BCA event. I think BCA may want to have a relook at it, because I think this would be definitely an issue going forward to meet the criteria and how evaluation is done. To answer your question, I think definitely the impact is there. The extent of it is still something that not clear yet, is evolving. I think at the right time, this has to be relooked at.
Thanks, Colin. Thanks, Kenneth. So, Colin, I believe that responded back to your questions.
Thank you.
Right. Thanks. Yeah. Right. when it comes to the end, time passed really fast and really good discussions. So before we come to an end, just a quick bounce off back to the speaker and panelists. Is there any last point that you would like to share from anyone?
No, I don't have any. Thank you.
Sure. Thanks.
Nothing from me.
Yep. Hi, Satya. Yeah.
No, nothing from me. Thanks.
Right.
Really, can I ask Kok Wei, from the perspective of the consultants and the SO rep who normally manages contracts, do you see any particular challenges or issues with the fraternity in managing COTMA as well as the current situation?
Now, currently, actually, to manage the COTMA, actually, at this moment is more through the contractor side. From consultant side, I mean, under the public sector contract, I think at this moment, most of consultants, what we can do is to catch up with all the submissions to the respective authority to get the respective clearance. I think this is what we can do. But as for the site work, we really depends very much on the contractors to so-called to get themselves prepared according to the restart criteria. So, but from the observation, we find that the work is quite slow at this moment. So not all the project that can restart with a quick momentum. That is, I think this is our concern at this moment. Thank you.
All right, thanks, Kok Wei. Right, so I'd like to take this opportunity also to thank our speakers, both Mr. Colin Chow from MinLaw, Mr. Satya from Allen Glehill for the papers, as well as our panelists, Mr. Chang Kok Wei from SD Architects and Associates, Mr. Kenneth Lu from Straits Construction, and of course, last but not least, our BCA colleagues, Ms. Lim Pui San, for the insightful sharing, and of course, my co-chair, Su Ming, and her team for all the effort to put this together. I think it's really timely. And also, more importantly, I think for the participation, we're very heartened to see there's a lot of participation. Yeah, registration was a lot, and now it's like 1,000. We have more than 1,006 coming in. So hopefully that this webinar has provided everyone with some general guidance and contract principle. It was a really good discussion, and we recognize that every projects are unique, and of course there are different issues. However, I think the general sensing for everyone, consensus is actually really important for us to look at finding an amicable solution together. Surprises is never good. I think coming together to discuss and then instead of going adversarial, I think we need to keep our energy, recharge our energy for better stuff. And of course, I would like to wish everybody well and stay safe. And over to you, Su Ming. Any last point? Yeah.
Well, the same echoing you, I just want to thank everyone for all your contributions to today's webinar. And yeah, to wish everyone to stay well, stay safe, and keep going. Thank you.
Right. Thank you. Have a good day ahead. Thank you, everyone.
Thank you. Back to you, MC.
Thank you.
Thank you. Thank you, webinar chairpersons, panelists, and speakers for the valuable insights about the public sector contract and cost management under COVID-19. It has been an engaging and fruitful session. We've come to the end of this session. After exiting this webinar, you will be directed to access an evaluation form for today's session. Once submitted, you will be able to download the speaker's presentation materials via the website as shown. Also, we are pleased to share that BCA is on Telegram, and you may wish to subscribe it to find out the latest updates and information on the built environment sector. On this note, we thank you for your participation and making this webinar a success. We wish you and project teams a safe and smooth restart. Signing off, this is Wei Wen from BCA.